Welcome to the 279th session of Legal Empowerment Through Interaction lecture series. We are reaching 280. It's the 279th session. It's a wonderful feeling. Today, we are on a very important topic that too dealt by the master himself. And to introduce, we have yet another person who has been into this field, who has been doing research, who has been doing so much of work in this field that I don't know how to put it. So it is, I'd say, that the masters are in action today. The topic, as you all know, is divorces that are happening around the world of marriages that are solemnized in India. It is said that like a hermit crab, you carry your personal law along with you. But are there exceptions? If you subscribe to or accept the personal law or the law of a different country, is it possible to have a divorce? And even if such divorces are obtained, are they recognized and accepted and acted upon in India? These are the different issues that we'll be dealing in depth, that too in a short span of time. Specific topic, the change in titles is that we have moved away from general topics to specific topics. So let me welcome the speaker of the day, Anil Malhotra, sir. Welcome back, part of our family, big brother back. And of course, our own sister, Mrinalini Deshmukh, ma'am, welcome. And all of you wonderful participants to this 279th session. Without wasting any time, may I just move directly to Mrinalini, madam, for the introductory remarks. Over to you, ma'am.
Good evening, everyone. It's always a pleasure and honor to be on this platform, as I was telling Sham before we started the recording. Let me wish all of you a happy Dhanteras, and we all have the real wealth of knowledge and wisdom which this platform is providing us, along with the other wealth which is entailed in Dhanteras. Today we are dealing with an exceedingly important topic, and I may be able to contribute in terms of what I have worked on it, not only as a student, but also as a practitioner who has done this kind of. I think it's very well put. Marriages are made in heaven, solemnized in India, and divorced abroad. What are the implications? Is there a specific law in the existing legislative enactments, whether it's a Hindu Marriage Act, Special Marriage Act, etc.? How has the law evolved? And what was it that necessitated the growth and the expanse of this particular law? I think this is all that we are going to hear from no less a person as erudite and as knowledgeable as Mr. Anil Malhotra. So I'm not going to really talk about it. But what I just wanted to give as an introductory remark is that when the enactment, that is the as we all know, it's personal laws are based on our religion, and they were enacted. The Hindu Marriage Act in 1955, Special Marriage Act in 1954. Probably this concept of a divorce taking place outside the country was not envisaged by the framers, because you don't find that in the framework of law as we speak today. So obviously the law has evolved over a particular period of time, and that too with the judicial pronouncements of the highest court, including the Supreme Court of India. So if I may say in a very general manner, there are 3-4 aspects when we talk about this law. Point number one, the main law, which is the law which has been developed is mainly, from my understanding, subject to Mr. Malhotra's. The main case is 1975 Satya versus Teja. I think that was a judgment in 1975, which was dealt with by the Justice Chandrachud, the father of the newly appointed Chief Justice, where they dealt with a situation where the wife had come to the court asking for maintenance under 125 or one of those provisions. And when the husband was summoned and he came to the court, he said that I have a divorce decree, you are no longer my wife, and I'm not entitled to it. She was taken by surprise because she didn't know what it was. At that point of time, the courts came to the rescue of such women, where they were given the option of getting an order from the court declaring such divorces obtained abroad ex parte by default judgments as not valid and not executable in a court of law in India. After Satya versus Teja was 1991 Narasimha Rao. Now in Narasimha Rao, it obviously captured what the thoughts and the legal intent, the intent of the case judgment was in 1975. And it really sort of laid down that what is the law which governs the parties and which is the law that governs divorce. And without reading the judgment, because I'm sure Mr. Malhotra will deal with it, the judgment says that the law under which the parties were married is the law under which they can get divorced unless both the parties voluntarily submit to some other jurisdiction. So I think this is the essence of 1991 Supreme Court judgment in the case of Narasimha Rao and Venkatalakshmi. Then we have different aspects of the law grew, whether what is a domicile, whether domicile is a factor for deciding. Then we have Sondu Rajini's judgments and so on and so forth. Now, in one of these, in the flow of these judgments, a parallel kind of proceeding started, and which are known in common parlance as an anti-suit injunction. Because there came a situation where the husband had filed, let's say the wife had filed in India, any proceedings, and the husband files for divorce there. Now, there are two different courts which are dealing with it. It could be divorce or it could be any other proceedings which are matrimonial in nature under the matrimonial law. And then how can the two courts go? What is the remedy available for the person who is in India, whether the wife or the husband? Whether there is any way that she can approach the court and the courts can tell the husband if he is moving in his proceedings overseas to stop from doing so or restrain him from proceeding with it. So this is used very commonly in commercial matters. You have the Modi Entertainment judgment, which itself speaks about what are the laws of the anti-suit judgment, anti-suit injunctions, but also in these matrimonial laws, and I have myself used it, and so I can say it from my personal experience, that these orders that the courts pass are the orders of anti-suit injunction restraining, let's call him, the respondent from proceeding in his proceedings overseas. Now, this is an order which is in personam. It is an order which is, again, the respondent who is before the court as one of the parties. Because the committee of the courts necessarily entail that the courts do not interfere in the functioning of the way the courts are working, and they cannot order any other court because all courts are supposed to be on an equal platform, unlike in India where you have a lower court and higher court and so on and so forth. So this anti-suit injunction also has developed over a period of time. And today we see numerous cases which are taking place because there are parallel case laws, parallel proceedings which are happening in India and parallel proceedings happening overseas. But effectiveness of the anti-suit injunction, and can I say that with a lot of sort of responsive, it's a very responsible statement I'm making. Unfortunately, at least some of the courts here in India, though they are able to understand the importance and the gravity of an anti-suit injunction, the execution of that takes time. Because I have seen in one of my cases where the Singapore court, the wife proceeded in the Singapore court and we filed in Mumbai court. We obtained an ad interim order against the wife, restraining him for proceeding abroad. When the matter came up in the Singapore court, the husband, without submitting to the jurisdiction, gave that order and said that Your Honor, this is the order that has been passed. And the respondent is, or the wife, let's call it, the wife is restrained from proceeding forward in this. The courts did not recognize it. The courts went ahead and passed orders, and this is my case as late as 2 months back. The courts went ahead and passed orders giving her whatever those custody rights, maintenance, etc., etc. So there was no respect given to the orders of the court because it was argued that these orders are in personam, and that is why the courts are not compelled. On the other hand, in another matter, a court overseas passed an order restraining me, my client, from proceeding in India. When that was brought to the notice of the court in India, they definitely said that there is a final adjudication on that petition. We are not proceeding. So Indian courts were very prompt and very responsible to respect the orders of the other court, though the orders were not against the court. At the same time, I found in my matter, the Singapore courts otherwise. So when we are talking about what is a divorce decree, what is the enforcement, these are the steps that come before a decree is passed. which is a part and parcel of this cross-border international divorces that take place, or they, as they call it, the NRI marriages and the NRI divorces. The parties could be citizens, or they could of India, or they could be other nationalities, but they are married under this particular proceeding. We also find a difficulty, and this is, I think Mr. Malhotra will agree with me, is to be able to convince to the courts, and that is where I think we are able to get that overseas, the irretrievable breakdown of marriage and separation for a period of 2 years, 3 years, as the case may be. I mean, different states in the US or in the UK or other European countries, they do pass orders based on this, that the marriage has been broken down or there is a separation. Unfortunately, that's not the case in India. There can be separation for 10 years, 15 years. The court says, no, nothing doing. You have to prove. In fact, Article 142, the Constitutional Bench, which had a hearing, I think, a couple of weeks or 3 weeks back, deliberated on this issue. And I think the unanimous, I would say to a large extent, the unanimous presentation that was made to the courts on behalf of different sort of sectors was that you cannot flog a dead horse. And somewhere the courts and somewhere the judiciary has to smell the coffee and deal with certain laws so that we can avoid all these things which are existing. I think that it's a whole gamut, and I think I can just go on and on, but we are not here to hear me or to listen to me, but we are here to learn from Mr. Malhotra, from the various case laws that have done, and how the law has developed, and what is it for students like me to learn from him if I have to use it in my practice over the course of time. Thank you so much, Shyam, for giving me this opportunity to make these introductory remarks. And I, as a lawyer, as a teacher, I would go on and on. I understand my restrictions in terms of time. And I would now like to hand over to Mr. Malhotra to make the necessary sort of, his discourse on this. Thank you so much.
Thank you. Thank you very much, Mrinalini Madam. It was wonderful to have you back, and for the introductory remarks. Let us also welcome Justice Ramakrishnan, sir. Welcome, sir.
Good evening.
Please, Anil Malhotra, sir, over to you. The stage is all yours.
Good evening, everybody. This is Ramakrishnan, respected Mrinalini ma'am, Premraj, and of course, Amitabh Bachchan of Letters. Though not 80 or 85 years old, just 45. It's nice. It's great to be coming back and to come back and talk of things which we really need to deliberate on, and something which is occurring to me again and again. Has Article 14 and 21 encroached in our bedroom? Now, let us analyze jurisprudentially how and why these changes are taking place. Now, historically, for Hindus, a marriage is a sacrament. A marriage is a halo, a holy thing, a union made in heaven. And as you see in old movies, it was a relationship for multiple births and rebirths. And that is why we never talked of divorce. And that is why divorce was so difficult. And there was no registration because the registration was implicit. So we had conditions to marry and we had conditions to get divorced. We came on a fault-based theory with 12 grounds. Leprosy has been struck off now. And we have a divorce by mutual consent. And we also have an alternative that when you have not been able to comply with the degree of restitution of conjugal rights or judicial separation, you can go for divorce. Irretrievable breakdown was never intended to be a part of Hindu law, and it never became a part of Hindu law. But then we are a constitution, and in the preamble, we have resolved to constitute India as a sovereign, socialist, secular democratic republic with justice, social, economic, and political, liberty of thought, expression, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, ensuring the dignity of the individual, unity and integrity. Now, is in this backdrop, what is happening? The gate of marital ties is opening, and through law of so-called live-in relationships, which the Domestic Violence Act also recognized by relationships in the nature of marriage, very guarded words to give protections, though it is not recognized anywhere else. We somehow have got the right of life and personal liberty, the due process of law, equality of laws, equal protection of laws, coming in slowly into the marital scene also. Now, why do I say so? Now, what is happening is that there are a number of decisions of the Supreme Court which are giving this light. So you, in Shakti Vahini versus Union of India, 2018, 7 SCC 192, it was held that the consent of the family or the community of the clan is not necessary once two consenting adults had decided to enter into a wedlock. Then came Shafeen Jahan versus Shopin, where the court noticed the society was going through transformation of marital relationships, and the right to marry a person of choice was held to be included in Article 21. And this, actually speaking, was a right to choose one's life partner as an important facet of your right to life, and the personal intimate decision should not be on the basis of recognizing them. Now, this thought process ultimately finds resonance in the 9-judge bench judgment of Puttuswamy, 2017, 10 SCC 1, where it is said that the autonomy of the individual, inter alia, in relation to family and marriage, were held to be integral to the dignity of the individual. Now, all these pronouncements came and have liberalized the right to choose, and you now have Justice Chandrachud talking very openly about relationships, how you can enter them and how you can maintain them, and it's nobody's business to tell you what to do. In Navtej Johar, we have struck down, we have decriminalized gay relationships. So what is happening? The entry is becoming more and more liberal, and the words given in the statute are being interpreted in the light of the Constitution. We never brought in the Constitution of India to interpret marital rights. This is a jurisprudence I see evolving over the past 5 to 10 years. This liberalization of thought is also now traveling to divorce. But the difficulty is that the divorce is hedged with safeguards. Now, there is a bad marriage, it has broken down. The family court or the high court has no power to use 142 for obvious reasons. It is a domain, it is an exclusive constitutional privilege of the Supreme Court only. For even the family court or the high court to use the words irretrievable breakdown would mean that you are actually reading into the statute what the statute doesn't contain. So what is happening? Irretrievable breakdown, I see, is creeping in through 13B2. Now, first, in the first part, I'll come to the case law. But the way I look at it is, now, Section 14 says that no petition will be entertained in the first year of marriage. Now, this is the first place the Supreme Court is coming in and saying they only live together for one day. Now they've been fighting for 10 years. So this 1 year bar also is a part of it. Then let us dissect 13B and see where is 142 coming, or where is the breakdown being read into. Now it says, on the motion of both parties not made earlier than 6 months after the date of the present petition, and not later than 18 months, if the petition is not withdrawn, the court shall, on being satisfied after hearing the parties and making such inquiry that the marriage has been dissolved, has been solemnized, and there is true, may pass a decree of divorce. So you go under 13B saying, we have been living separately for 1 year. We have not been able to live together and our marriage should be dissolved. So the court issues first motion, and then the court issues second motion after 6 months, but not later than 18 months. Now, should the 1 year be condoned? Because marriage is broken down irretrievably. Can you read into statute? And second, should you wait for the second motion gap of 6 to 18 months, or you use your extraordinary power, even though through the family court or the high court saying, no, there is nothing survives in the marriage. You use pseudonyms, you use a phraseology equivalent to breakdown, and you start saying, no, there is nothing left in this marriage. We have to dissolve it. Now, the ugly part of it is, with this litigation comes settling of scores, child custody, 498A, 406, 125, Domestic Violence Act, an anti-injunction suit. So there are 6 litigations. Now, where parties cannot live together, and thanks to the efforts of well-wishers, this litigation develops into 6 more litigations, and by the time anything happens, there are rock-hard attitudes not willing to settle the matter. So you spend 20 to 25 years, and ultimately you go to Supreme Court, and Supreme Court says 142, finish it off. Now, is this going to happen for a long time? Statute has to answer. But still, as I was discussing with Nalini ma'am before we started, we have to think of breakdown of a marriage as an additional ground in the light of the perspective that we have liberalized our thought process of entry into marriage. So therefore, why not have these constitutional principles applicable at the exit point also? And this is what a 5-judge bench is looking at. Why and how should we use 142? Now, how did this confusion develop? This has been seen over a number of judgments, but if we look at the judgment of Amardeep Singh versus Harveen Kaur, this is 2017, AIR 2017 SC 4417. Now, in this, there has been a lot of interpretation done. So in this judgment, the Supreme Court is saying whether the minimum period of 6 months stipulated in 13B2 for motion of passing the second decree can be relaxed in exceptional situations. This is the question they have coined. So they say first, they say there is a conflict. So the bench looks at Manish Goyal, 2010 4 SCC 393 to say that the jurisdiction of the Supreme Court under Article 142 cannot be used to waive off the statutory period of 6 months before filing the second motion, because it is in contravention of the statute. Now, then the Constitution bench also in Supreme Court Bar Association 1998 4 SCC 409 had said that this power of statute should not be used, which it does not as read in the statute. But at the same time, Article 142 has been exercised in cases where the marriage is broken down. And in Poonam versus Sumit Tanwar, this is 2010 4 SCC 460, the Supreme Court cited a number of decisions and dissolved the marriage. Then in Niti Malviya, 2010 6 SCC 413, the court said there is a conflict between Manish Goyal and Anjana Kishore, and then the matter was referred to a bench of 3 judges, but it became infructuous because the parties resolved the matter. Now, be that as it may, despite Manish Goyal, the power under 142 has been used very, very often by the Supreme Court in dissolving marriages, and there are at least 20 decisions cited in this judgment. And the Supreme Court also notices that in Anil Jain versus Maya Jain, 2009-10 SCC 415, one of the parties had withdrawn the consent. The court said the marriage is broken down, and though the civil courts in the High Court did not exercise the power statute contrary to statute provisions, but Supreme Court can exercise such power in the interest of justice, and decree of divorce was granted. Now, the Supreme Court in this case of Amardeep Singh versus Harveen Kaur said that after considering the above decisions, they said we are of the view Manish Goyal holds the fort, and in the absence of contrary decisions by a larger bench of the Supreme Court, the Constitution bench, the Constitution power cannot be exercised contrary to statute, especially when one of the parties is disagreeing to the grant of divorce. So in this judgment, the Supreme Court said that the consent grant under 13B2 cannot be a subject of 142, and it is not a mandatory provision. It is for the court, that is the family court, to decide this. And in para 16 they say the object of this provision, that is 13B2, is to see if parties can dissolve by consent if the marriage is able to be broken down, to enable them to rehabilitate as per options. And then the object was not to perpetuate a purposeless marriage or prolong the agony of the parties when there was no clear chance of reconciliation. Then the Supreme Court ultimately goes on to say that applying the law, they are of the view that only if the family court is satisfied that a case is made out for waiving the statutory period under 13B2 for second motion, the statutory period of 6 months in 13B2, in addition to the statutory period of 13B1 of separation of parties, is already over before the first motion. All efforts for mediation have failed. Parties have genuinely settled their dispute of alimony, custody, and the waiting period will only prolong their agony. They said it is only on these conditions that the second motion waiver can take place for the second stage. And the waiver application can be made within 1 week of the first motion, giving reasons. Then the waiver is to be granted at the discretion of the court. And they very clearly say 13B2 is mandatory. Is not mandatory, but directory, and it will be open to the court to exercise its discretion in the facts and circumstances of the case where there is no possibility of parties of resuming cohabitation and there are chances of alternative rehabilitation. So you have the Supreme Court in Mandeep Singh versus Harveen Kaur saying that these are the 4 conditions when the family court can waive off the 6 months waiting period in the interest of the parties after recording these discretions. Now, this judgment of 2017 has really not found favor because we have the 5-judge constitutional bench now looking at the issue whether at all 142 should be used to dissolve marriages, and can 142 be used if one party has withdrawn consent? And what should be done in the circumstances? Though decision lacks. But what I want to bring out also is an additional situation is two cases which I have noticed. One is Pamela Sharda versus Rama Sharda. This is a decision of the Supreme Court unreported in civil appeal number 11,714 of 2012. And it is a decision of 15th of July 2013. Now, this was a case where the man was litigating and he wanted his wife to move out of the matrimonial home because it was causing a lot of discomfort and it was causing a lot of problems with his mother. So the Supreme Court said you pay 45 lakhs in full and final settlement, and after 45 lakhs, no more. And once this alimony will be paid, the marriage will be dissolved and there will be no claim of any party, and the wife will live separately from the husband. So this deal of 45 lakhs or the settlement deed was, so to say, used or utilized to end a bad marriage. Then again, in the decision of Manju Kumari versus Avinash Kumar, the Supreme Court, this is the citation is AIR 2018, Supreme Court 3629. The Supreme Court exercising its powers under 142 and noticing the judgments in Naveen Kohli and Sangamitra Ghosh, they said, parties may live peacefully and their daughter will be settled properly in a life. Quietus must be given to all litigations between parties. Such an approach would be consistent with the approach adopted by the court in earlier matters. So it says, husband will pay a total sum of 10 lakhs and there is an installment plan, and in view of the peculiar facts and circumstances, they are using their power under 142 to do substantial justice and declare dissolution of the marriage subject to the fulfillment of the conditions. And all matrimonial proceedings will come to an end. So this is another case that Supreme Court is using its extraordinary jurisdiction to settle the dispute and bury the hatchet. So now, in my humble view, what is happening is that noting Naveen Kohli and noticing Vishnu Dutt Sharma, Niti Malviya, V.D. Bhagat, Anil Jain, Maya Jain. Now, these are all cases where Supreme Court is using its power under 142. Now, the moot question is, should this power travel down? Should this power be watered down into practice directions? Should the family court start using this power? Now, the judgment of the Supreme Court in Amardeep Singh versus Harveen Kaur is very clear that this power is to be used only by the family court. But then you have the Supreme Court using 142 day in and day out. And now you have the Constitution Bench judgment examining how far irretrievable breakdown should go. Now, I want to bring in another perspective of the problem, which also requires an attention and which I have made my submissions online, is when parties are married under Hindu law, they move to a foreign jurisdiction. Either both or one of them uses irretrievable breakdown in the foreign jurisdiction. In a foreign jurisdiction, a marriage is a contract, so the only ground available for divorce is breakdown. So because they are domiciled in that jurisdiction, the breakdown ground is used, a one-line judgment is passed, but one of the spouses comes back and says, I never got divorced like this. This is against law. There is a problem. And let us suppose, even if both parties have agreed to it, what is the status of a divorce obtained on irretrievable breakdown abroad? Does it dissolve a marriage in India? And as Nalini ma'am referred, this Teja versus Satya in 75 Supreme Court said that these are limping marriages. You are married in India but divorced abroad. Then you have Narasimha Rao, Neerja Saraf saying no, it can't be. Then I assisted the bench as an amicus in Rupak Rathi versus Anita Chaudhary, where we read down Narasimha Rao and explained. And the bottom line is, if there is a foreign judgment presented on breakdown and it is brought before a court in India in response to a divorce petition filed by a spouse, can a 711 application make the Indian divorce petition disappear? Answer is no. It is to be made an issue. Pleadings have to be coined, and it is to, in the test, the judgment has to stand the test of 13 and 14 CPC. If it doesn't, then it fails. So what do I advise my litigant clients? Don't get into a mess. You've got a divorce on breakdown. Now you record a settlement, make your foreign divorce decree a part of your settlement, present it to the court in India in a 13B petition, and your foreign decree be made part of the settlement. Appear online through power of attorney holders. It is well known now that you can do this. Appear before the judge, tell him we have recorded a settlement and this is our settlement. Your foreign divorce decree may be a part of the settlement. Resolve your matters in India. The divorce brings to an end 498A, 406, 125, DV Act, Anti-Injunction, Child Custody. you have to wrap up these proceedings also. And as Nalini ma'am very rightly said, if there is a 40A, 498A and 406, it can only be got rid of after a mutual consent divorce and a 482 CRPC read with 227. It has to be quashed. It's unfortunately, it is not compoundable. So therefore, keeping a 498, a 406 alive after a foreign divorce decree without an Indian divorce is meaningless. So the exercise is do a 13B divorce, then go under 227 and read with 482 and finish off your criminal proceedings. Now, we are going around in a circle instead of coming straight from end to end. At the entry point, we have brought in 14 and 21. We are liberalizing rights. And it has been recognized up to a 9-judge constitution bench of the Supreme Court. But at the exit point, we are not reading down. So this is, I think, a dilemma which we face. And we face it because there is no provision for reading down. It's very difficult because word irretrievable breakdown of the marriage having failed doesn't come in anywhere. And if it is, it falls opposite to the fault theory which we recognize in section 13. So this is a sort of a quagmire, as I can say, or a complex legal dilemma which has evolved. And the only way to resolve it is that the statute has to be amended. Now, we came with a bill in 2010 to dissolve the marriage by irretrievable breakdown. This was based on the 217th report of the Law Commission in 2009. So the efforts are there, but they have not led to anything concrete. So I personally feel we must have irretrievable breakdown as an additional ground, the fourth ground, hedged with safeguards that all issues of child custody are settled, all maintenance issues are settled, alimony is settled, property issues are settled. So, and it is available, let us say, to start with, where both parties are agreeable, and if parties are OCIs, it's very important. Now, recently I came across a very complex Australian matter, where an Australian court is, now in Australia, you can actually settle your matrimonial property without a divorce. It's a very unique principle. You draw up a settlement, you go to court and you divide everything. It's a Hindu marriage. There are substantial properties in India. There are substantial properties in Australia. The moot question was, can an Australian court take in all the Indian properties also as part of the settlement? Because according to Australian law, it's 60-40 or 50-50. The man says, these are my self-acquired properties. Some of them I got after marriage, but acquired after marriage, but some are before marriage. But the Australian court says no. My thinking is that an Indian court can decide on Indian matrimonial property only in a petition under 13 and where section 27 is to be read for settlement of matrimonial property. But the question is, they said the Australian court is not going to bother. And what is the Australian court going to do? I said, what if you get an anti-injunction suit? He says, what the court will do, they will total up 60, they will total up 40. He says, if I don't make the property available, they will deduct the cost of the property from my share and go on. So this is the complexity we are putting Indians and Indian property to. So to resolve these rights, there has to be a solution. There has to be a via media. We have, again, I come back to the moot question. We are working only on the entry, but we are not working on the exit. And that is why I said, solemnized in heaven, married on earth, and divorced abroad. So, or you can call it marriage, settlement, divorce, and bliss. So on this note, I throw the floor back to Shyam for views, for reactions, and comments on my thought theory, an easy entry and a difficult exit? Are you going to clog the system? Over to Shyam.
Thank you, Anilji. As usual, wonderful. I'll go straight to Justice Ramachandran, sir.
See, right, a liberalization at the point of entry is recognized under law because even if you go by the provisions of the Act, matrimonial law, what is required is consent between the marrying parties, not others. If they decided to live together, they want to contract a marriage. Only thing is the age, 21 and 18, what is provided there under the marriage laws, that they will have to. If it's the case of a Muslim, the puberty, etc., will be taken into consideration for the purpose of granting it. So there will not be any difficulty for the purpose of the entry become liberal, because he is already there in the right of the parties to choose how to live, because living together has become a common thing now. If that can be possible, even the gay marriage, that is also now made liberal, because they can decide in what way they will have to reside together. So those are all the things where there is no restriction as to how this will not be done, etc. So that is the reason why the Supreme Court has said that you have got a right. Your right cannot be intervened by anyone, because it is a personal right between the parties as to how they will have to live. But as far as the exit is concerned, there is a restrictions provided in the Act itself. Only on certain grounds you can go for a divorce. So unless it is within the legislative domain to decide whether irretrievable breakdown can be made as a part of the grounds of a divorce, even then the Supreme Court has said, who has to decide it? If it is 13B, no difficulty, because they can say that we have decided because we are not able to live together. The court is need to only consider that there is a collusion between the parties for the purpose of getting something else. This is as being made as a ruse for the purpose of getting a divorce. But all other things, if there is a satisfaction that it is a genuinely made application, they are not able to live together, because parties also decided it is not possible for them to go with a relationship, the divorce can be granted. Only thing is the 6 months period. There also Supreme Court has in different cases, but conflict has at least now said only under Article 142 we can exercise that power, not the liberalization cannot be possible. As regards the consent withdrawn by one of the parties, I think that Prem can help us. There is a decision by the Kerala High Court, Kerala High Court or Madras High Court, which said that once you have filed an application, later you cannot withdraw it because there is a consent. You have decided to live separately, you have decided there is an irretrievable breakdown of marriage, but they cannot. But I think that it is against the Supreme Court. But I don't remember the citation, but Prem can help us, it appears on that. There are either by Kerala High Court or Madras High Court has said that once an application has been filed by mutual consent, merely because one of the parties want to settle down his or her rights on other, because after getting the benefit out of the compromise of filing an application for 13B and file an application, thereafter you cannot withdraw from that, because you already, the person who has already enriched by virtue of the compromise cannot go back after getting that benefit. That is the principle laid down in that decision, if I remember correct, because I don't remember the citation. So as far as the irretrievable breakdown is concerned, even if it is introduced in the law as a ground under section 13, who has to decide it? Suppose one party says, no, there is no irretrievable breakdown, it is on the part of the default, on the part of the other side, she is not able to reconcile with me. Then also the burden, the responsibility is always on the family court to decide there is an irretrievable breakdown of marriage, only to deny the legitimate right of divorce, that the husband or the wife or the other spouse is clogging on the relationship for the purpose of what do you call, making difficulty for the other side to have a peaceful life. So I think that unless the legislature come with the, and I think that even merely because you say the irretrievable breakdown of marriage is made a ground, you will have to define what is irretrievable marriage also. Otherwise, there is a possibility of conflicting opinion being coming on that also. You will have to lay down the principle under what circumstances it can be said there is an irretrievable marriage. When those conditions are proved, you can do it. So this is on my view, because merely because introducing provision for a ground for irretrievable marriage is all will not be sufficient. The conditions or the definition of irretrievable breakdown also will have to be defined under the Act itself. This is my humble view for the purpose of resolving the issue. It is right, as Anil Malhotra has said. Now, it is not made in heaven; it is made in earth, and it is decided as to whether it will continue or not to continue is also made between the parties in the earth only, not in the heaven. Because if it is being done in the heaven, everything want to go on peace, adjustment, giving up and take, give and take policy. But that is now slowly eroding now. And everybody wants something to be settled on account of the divorce also. If you go by the family courts, the fight between the parties is not on the purpose of the protection of child's right or protection of the matrimonial home or keeping the relationship between together, but how to score what they want. That is the only thing that is going on. And this is my humble view that the mindset will have to be changed. The entire concept of marriage will have to go back to the one. See, even in the foreign countries, I don't think the divorce is not so easy. There are restrictions. They are now thinking of how far their divorce or what do you call this indiscriminate divorce affecting the right of the child now, affecting the character of the child. Now the thinking has come in that way there also. Now we are now going to the stage where they are retrieving back. And now in India, we say that the Western country is liberal, we want to get it. But if you rightly say, if you analyze it, I think the position is converse there also because of the understanding of the family relationship and the relationship between them, how far it have impact on the child's upbringing is also one of the points that is being taken note of by the family courts there also. Before deciding to divorce, they are thinking about the right of the children, how they will have to be brought out, how the mindset, the character or the stress that is likely to be caused in the child's the upbringing should not be affected on account of the separation of the parties. These are all the areas where I think that the society will have to also think about it, and the legislature will have to think about how this can be reconciled and how it can be resolved in a beneficial manner for the purpose of protecting the society and the family, because family was supposed to be the unit which decides the existence of the society itself. That's all my view.
Thank you, Ramashan sir. May I request Justice M.V. Ramana sir, please, your comments.
Thank you, Mr. Shan. Anyway, I really agree with Mr. Malhotra that there should be a ground in one of the provisions of Hindu Marriage Act, or take it even in Special Marriage Act, to enable the parties to go for divorce, saying that they are not in a position to reconcile. That particular provision must be incorporated. I think it's high time, because the experience shows that the court ultimately, after recording the evidence of the parties in a family litigation, in a divorce petition or in a petition filed for restitution of conjugal rights, almost comes to a conclusion. I can say out of experience that every court definitely feels ultimately that the parties are not in a position to adjust themselves to remain in family. So there should be there should be a ground, among others, for granting divorce on the basis that the parties are not able to pull on together. That is nothing but irretrievable breaking down of marriage. As suggested by Justice Ramakrishnan, safeguards must necessarily be incorporated while amending New Marriage Act for this purpose, defining what is irretrievable breakdown of marriage. And my personal view is that ultimately court has to be given, or court has to be empowered to make out this ground basing on the material before it and evidence before it. Because the court will be the ultimate assessing authority and evaluating authority while considering grant of divorce or otherwise. In such a situation, when entire material, though the parties deny that there is no such situation, the court must have complete power and it must have that freedom to come to a conclusion ultimately, either in the interest of justice or in the interest of the parties themselves and for their benefit. Okay, to come to such conclusion that there is no marriage as such subsisting, and the high time that divorce is granted. So to enable the parties to live in peace. And one more safeguard as suggested by Justice Ramakrishnan to be taken care of is, to be looked into is the issue relating to children. Children should not ultimately become victims on account of this litigation. In every case, almost, as the experience shows, the children will be at the receiving end. The children will be at the receiving end. There must be some protection for the purpose of children and to take care of their interest once this amendment is brought out. So this is my humble view. I support Mr. Malhotra on this.
Thank you very much, sir. Before we go further, a question that has come up, Malhotra sir, is that Hindus of Kerala, married in Kerala, had gone abroad, employed in Dubai. They got a divorce under the Sharia Act. There are two legs to this question. Number one is that how far is that divorce obtained under the Sharia law acceptable or implementable in India? Number two is that now the father has given a custody petition saying that under the Sharia law, father is the ultimate custodian of the child. So the divorce having been granted under the Sharia law, he is having exclusive, he should be given exclusive custody of the child. What exactly is the scenario, sir?
See, I would straight away answer this question by saying, if you are Hindus by religion, the Sharia law will not apply to you. You cannot invoke the Sharia law. In Dubai, there is an alternative available to you. If you are not Muslims, you can avail of a law which is available, by which divorce is available to you according to your personal law. They have that option. So, if your divorce is obtained under Muslim law when you are Hindus, as far as India is concerned, the decree or the judgment is void ab initio. And therefore, the second part of the limb, where the man has got custody rights, courtesy the Sharia law divorce decree, would also stand. But the lady has to enforce this in India. She will obviously not be able to enforce this in Dubai. So the answer is to file, not a guardianship petition would not be available. The option would be for the woman to file a divorce petition in India and claim custody under 26 if she has relocated to India. How far is the man going to agree to it is again going to be a very difficult question. But if we test this on the anvil of section 13 and 14 CPC, this decree of divorce on Sharia law is void straight away.
So what if the husband comes over to India and files an application for implementing that? It is not possible, right? In view of this.
The courts to try all suits unless barred. Section 9 CPC. Plain and simple 711 application that this judgment is on 13 and 14, which is not according to the law or personal law of the parties, which is statutory. Therefore, this decree can't be enforced. This order can't be enforced. Court need not even go into it. A 711 application can serve the purpose. But you need a smart lawyer like Prem to do this.
Absolutely.
See, Shyam, the problem is, unfortunately, our brothers in the district bar are not so well equipped in terms of money. This private international law, as Munalini ma'am and I put it, it is now called international family. You have to be a practitioner and you have to be a scholar of international family law to do these litigations. People in Mumbai have matured to that level, in Kerala have matured to the level because you have very good family courts. In the other part, east, west, and north, it's very, very difficult. Nobody knows anything. The judges don't know anything. The lawyers don't know anything. Who reads? Nobody knows. So it's a very complex situation. But the straight answer is no. I mean, I can read it down to you the way I did it. And that's it. But the problem is the man has to come to India. And if I were the lady, I would file a writ of habeas corpus and get the child back. saying I'm the natural guardian, he's imposing the Sharia law on me. Till the guardianship court decides, give the custody to me, and a lawyer like Nalini ma'am can handle this litigation easily.
I have something to add, Shyam. May I do that?
Yes.
Sure, please.
I am
Okay.
having a doubt, sir. Dr. Raghuraman. Dr. Raghuraman, sir.
Yes, sir. Can we just have Mrinalini ma'am's statement and then we'll come back to you, sir. Just give us a minute, sir.
Thank you, sir. Thank you.
Please, Mrinalini ma'am, please.
So what the case which you are referring to, and we deal with these cases very often. It is a quicker and a sharper, shorter way of getting a divorce in Dubai. So the choice is given to the litigant when he goes to the court of the first instance in Dubai, whether you want to go under the Sharia law or the non-Sharia law. The non-Sharia law is Hindu law, Parsi law, etc., that we are talking about. So when they go under the Sharia law, there is no, under the jurisprudence of Dubai matrimonial law, they do not verify whether the parties are Muslims by religion for the purposes of deciding this. Now, any petition that comes to a family court in India, and the act under which we go, there is one of the mandatory administrative column, which is the procedural column, which is there, is the religion of the parties. Because sometimes we see cases where, and I've dealt with a lot of these cases, then we have to go under the specific relief act, where a Hindu and a Christian, or sorry, Hindu and a Parsi get married as per the Hindu Vedic rites. They do the fairas, etc., etc. It's a very happy situation. It is when they come for divorce and they say we want to take a divorce under the Hindu Marriage Act. But hello, stop here. You were not a Hindu when you got married to her because you were a Parsi, you did not convert. So your marriage is void ab initio under the Hindu Marriage Act because the act entails that both the parties have to be Hindus at the time of marriage. So if you have not converted, then that marriage is not in existence at all. So similarly, in this case of a Sharia law, if somebody were to file for a Muslim law in India, they would first check the religion of the person who has approached the court. In Dubai, unfortunately, it is presumed that all who come to the court are probably, Sharia law is applicable to them. And secondly, in this case, I don't know what the query is, but was it a judgment given in default? Was it given by?
No, it was by consent. Both parties had participated.
So then I think that though it is null and void, as Mr. Malhotra rightly said, the Narasimha Rao judgment does prevail, that where it says if you have voluntarily chosen a jurisdiction of your own choice. So today for the woman now to come back and say, in my view, that okay, they have done it under Sharia and then I don't have the rights, so on and so forth, could be a little difficult for her to explain, because that when she had gone for divorce by mutual consent under Sharia law, being a Hindu, she would be assumed to be governed by that act because she had submitted to the jurisdiction. We need to understand what was written in the petition of these parties as to how they are governed by the Sharia law. I think that is very important to understand. Rather than
if I may add one thing, both parties, to my understanding, are satisfied with the divorce. But once it comes to the custody, Indian law is better because it's the welfare of the child. Whereas Sharia law, there is no question of welfare. It is a father till majority or till marriage. I'm not very sure about that's the issue.
You are right. You are right, Shyam. That is exactly what the situation is. But if they come under the Guardians and Wards Act, in that sense, it is a secular act. It doesn't concern whether you're a Hindu or whatever the case may be. So then she could go under the Guardians and Wards Act if she's able to show that the child is normally domiciled or habitual resident of India, if the case may be. So there are certain preconditions for that also for the filing of the petition. Not mere.
Another issue is that child was born. Till now, the child has never seen India.
Okay, so I think it would be difficult to go under Guardians and Wards Act because you can't say that he's a habitual resident of India. That is one of the preconditions of the Guardians and Wards Act. So they may have to go, and if she goes under the Hindu Minority Guardianship Act, even then the child is not residing in Dubai. So you cannot choose. It's not like that you can choose, do forum shopping, if I may use that word, for the purposes of what really caters to your requirements. That's what.
Absolutely.
I just like to add here.
Yes, sir.
The only way out is, as ma'am has very rightly put it, GWA will not be available to you. Section 9 does not ordinarily decide, you are out. So the only way out, as people do it, is you file a petition under 30 for divorce, saying I was coerced into a divorce, I did not understand it, blah, blah, blah. Resign and say I want a divorce And then you very conveniently push in an application under section 26 for interim custody or visitation or access, and tell the judge, please decide my 26 first. And in the 26 you say, I did not agree to it. 13 and 14 makes a decree invalid. Please decide my custody interim and give me custody. That is the
But-
only thing to sort it out.
But she doesn't want to invalidate the divorce. I think she's happy with the divorce.
Both are happy with the divorce, but the child custody is the issue now.
So there is no question of both of
The 26 application is only the via media for the custody.
Right.
Once custody is obtained or sorted out, agreed to, consented to, and recorded in the Indian family court, you can withdraw the divorce petition.
Correct, correct.
That is the only way to do it. You see, you have to use the backhander. You want the divorce, you want the cake, and you want to eat it.
Want to eat it or do. Right. Sir, can we move on to Raghuram, sir? Please, sir.
Yes, of course.
Sir, a small doubt which is in my mind for many years. A live example has come to me. A divorce decree was passed in a foreign country, that is Denmark. The marriage has taken place in Hyderabad, and the one of the grounds is causing a grievous hurt by the husband. Both are living in Denmark, and the divorce was granted after both sides have engaged an advocate on merits by a lower court. And the child custody, because the child's age is about 14 years, after 3 or 4 interviews independently by the Department of Social and Family Welfare, the child custody was exclusively given by the court to the mother. And now the question is, the mother wanted to bring a certified copy of that decree passed on merits. The court consists of a judge and 2 members. You can call them as members of the judicial members or whatever that is the law in the Norway country. And now the criminal case, he was convicted and community service 3 months was given, and now he has put an appeal before the higher court on his challenging his conviction. And now the girl wanted to know what is the enforceability of the divorce, which court she has to file, either in the family court or high court, that the copy, the translated copy of the divorce decree from the foreign language is also being prepared by the court people in that country. And so they wanted to know whether what is the importance of section 13 of the CPC, which says that the foreign judgment must be tested on the lines of it is not obtained by fraud, or it is not obtained by what do you call it, without jurisdiction by the parties. All these things they want to know. So because one of the lawyers appearing, he said that 13 of the CPCs also must be brought into picture, because that is the advice he has got from seniors also. I want this small problem. It is not a single problem. I have come across another couple also in Europe. They also obtained the decree of divorce on cruelty of the husband on one of the grounds. So that is why, as you said, Malhotra said, it is a contract in those countries. And they can just file a divorce decree, any of the spouses. There is nothing like that sacrament or all these things are not there in Denmark, Finland, and Sweden and other countries, as SAR knows. So this question was agitating my mind, because the divorce decree is already passed 1 year back, and now they wanted to file this certified copy. Which court they have to file, whether it is a family court, if there is a family court, and that girl's place of birth is in AP, but marriage has taken place in Hyderabad. Both spouses were married in Hyderabad. That is the problem. So they are waiting. They did not move the family court or any other district court in their native place. They wanted some expert advice, which I may communicate, or I communicate to their lawyer, and they can pursue the matter. That is why.
First of all, by a little question to you,
Hmm.
what is the purpose or what is the objective in recognition of that foreign divorce decree in India? Is there a dispute? Is it to claim?
No dispute. He may come and challenge that. He may come and oppose that decree is not valid. That is their worry. That is the main worry of that girl.
Who will oppose it? The man will oppose it.
Man will, because now they are on employment visa, both of them. So
Are both of them Indians by origin? Hindus by
yes, they are Indians. They are born in AP.
Okay. So my question, straight answer to you is, you are actually going into a litigation which you don't need to do.
Okay.
See, why should you create a problem, or why should you bell the cat on your own neck?
So that is also okay.
So it is only when the man comes and questions the decree and he challenges it that you will appear as a respondent to say, tested on the anvil of 13 and 14. It satisfies 13 and 14. It is in procedure in accordance with law. It is not violating principles of natural justice. It is not ex parte. It is obtained by consent. It is obtained on a fault ground. There is no inconsistency. It is on merits. There is a decision. So I think you should not invite trouble by running to court. Instead of saying, put a stamp of legitimacy on it, you should wait for him to come and say that this decree is wrong. It's null and void.
So
You see, it is like you are innocent till proved guilty. So your decree is valid till proved invalid.
Okay.
So my straight answer to you is, rather than you going around looking for recognition, you should wait for a challenge to the recognition and answer it.
Okay.
Second.
I will put it another way, hypothetical question, Anil Malhotra.
Yes, sir.
Suppose if it is no enforceable decree and there is no enforceable term or to be executed is there, I don't think that is not required. One. Secondly, suppose she wants to have a remarriage, whether this divorce can be accepted by Indian people. Say that your first marriage has been dissolved and you can have a right to remarry.
This is what Sir Narasimha Rao's judgment says, no? That it says that unless the voluntarily submit to the jurisdiction of a court and the order. So that is the exception which has been carved out in Narasimha Rao's thing. So in my humble view, it would be considered as a valid divorce. She does not need to seek a declaration in India that she is divorced, because she has got a valid decree of divorce which cannot be challenged, because as I understand from Sir, it is by mutual consent. So both the parties have voluntarily taken a divorce by mutual consent. So where is the question not being recognized here, if at all it comes? Because for the execution can only be required if there are some assets that she has to sort of, as per the understanding, some assets have to be acquired by her which stand in India and that she will not get this. But if there are no other fallouts in terms of the ancillary reliefs, and it is only simplicity, then
let me interrupt you for a few minutes. It is not by mutual consent, madam. It is by violence. He was convicted. That's why she has approached the court saying that it is cruelty, physical cruelty, and the court has accepted and passed a decree. That is the.
He appeared and contested.
Yes, he has appeared. Yes.
That be the case. It's not a question of ex parte decree or without principle of violation of natural justice.
It is not an ex parte decree. He has.
Sorry to interrupt you. It is a judgment on merits. Till it is upset in appeal, till he challenges it, it is valid. Suppose he does not challenge it within the limited period of appeal and it assumes finality, it is final. If he has challenged it and he has lost his appeal, still better. What is the status on appeal?
Appeal is not filed. That they said that their law says there is no further appeal unless there is.
Then it is final.
Then it is final, sir. In this view, I would say that this is a valid and a recognized decree in accordance with 13 and 14.
Okay.
Proceeding to challenge this would lie in a family court Because under section 7, explanation A, it is said the suits and proceedings referred to in this section are proceedings which are within the jurisdiction of family court. A suit or proceeding between parties to a marriage for nullity we can read out, for or dissolution of marriage. So if there is any suit or proceeding relating to dissolution of marriage, then section 7 says family court has jurisdiction, and section 8 says that where a family court has got jurisdiction, all civil court jurisdiction is barred. So
Yes.
the second question would be that if a proceeding arises, you cannot go to the civil court on a declaration of a decree of divorce. It has to go to the family court. Second question, you should not fire the gun and invite trouble. You should wait for him to come and say it is an invalid decree. And then you turn around and say, this is a final decree on merits. There is no appeal provided. Maybe in that country's court, there is a constitutional law provision or a very complicated reference which he can avail of, which he is not availed of, and it is the end of the story. I don't think it is the quietest to the matter.
Okay.
So rather than inviting trouble, you should wait for trouble to come to you.
Yes. Okay, sir. Thank you, sir. Thank you for your kind advice. It is really helpful to them because their father and mother, they are coming to me, and I luckily I had this session.
No, sir, you can. You can find me on YouTube. You can see my website anilmalhotra.co.in, and you can contact me if you ever have an issue.
Yes,
And if you want the parents to have a dialogue, feel free.
yes. Thank you, sir. Thank you. Thank you.
Anything to be added, Anil ma'am?
So I was
sir.
thinking that, sorry, sir, please go ahead.
No, I mean, he just want to know, I mean, anything more to be added from your end?
No, so I was just saying, if I'm reading section 7, and the explanation which is given there in the Family Courts Act, it says a suit or a proceeding for a declaration as to the validity of a marriage, which is different, or as to the matrimonial status of any person. So maybe if at all she needs to go to seek a declaration that I am, though I was married in Andhra Pradesh and I have got divorced, and to that extent, if required, but don't take it as a first option. It should be only as a last option, because today, fortunately, the lady is armed with a very good order of the court, which is non-appealable. So I think she should sit back and relax.
Thank you, madam, for your kind advice. Because it's a practical problem which has come up from that country.
Yes.
So the moral of the story is that, or the quintessence of the discussion is that your client can get remarried.
And you can invite Pranali ma'am to the
I
wedding.
think both the spouses are free to marry, I think.
So the husband is lucky to get a freedom without contesting it, So I think he should make the most of it and move on in life rather than.
But he was given a sentence of 4 months community service, but appeal is pending.
That might be because of the cruelty aspect, man.
That is, he was convicted and 4-month community service. The criminal court in that country has asked him. He has already, I think, filed an appeal, criminal appeal, not for divorce appeal. That is also there.
Thank you, sir. Thank you.
Thank you, sir.
For your participation as well. Anything to be added, Ramana, sir?
Oh, nothing. Yes, very.
Okay. Yes,
Very
we
interesting discussion.
Mr. Rao wanted to say something.
Yeah, that's what I'm saying, because he is waiting for the concluding remarks, and I am asking him or requesting him, as we come to the end of the 279th session, may I request KVJ Rao sir to render the concluding remarks, please.
Shyam sir, Anil sir and Melanie ma'am, as usual, a very beautiful presentation. What we are facing today is nothing but the effects of globalization. And people
So,
and
sir, that is why, sorry to say, my 9th book is called Global Indians and the Law.
correct. No, I agree with you.
We are everywhere. You go to any country on earth, you will find that an Indian is there, already there. And they say we came right after partition in 1950.
Yeah. So, like coming back, so the problem lies is we want to have the cake and eat it too, and that is not going to be possible. And Malhotra sir, we've been discussing this from at most of your topics is the law is not keeping up pace with the changing situation. And we are reactive, we have never been proactive. The problem with our thinking is till it affects me, it's not a problem. That's what our parliamentarians look at it. If it affects me, it's a problem. If it doesn't affect me, it's not a problem. We can handle it. We'll cross the bridge when we get to. That is the refrain mostly from parliament. कि हम लोग क्यों करें? कोई और करेगा तो हम देखते हैं. So so that has also been a problem. And yes, when we talk of 142, we have to understand that today, if the Honorable Supreme Court gives the powers to the family court to decide everything, then other courts will start asking for the same powers. So we have to be a little bit careful. And if I'm not wrong, it has already been decided in Supreme Court Bar Association versus Union of India that 142 cannot violate statutes. So, and now, as you said, the Constitution Bench is also looking at it. So we'll have to wait and see how it goes about it. So, I mean, 142, yes, is good if it is doing good to the parties. But then if that becomes the general law, we'll have a very, we'll have a situation where every family court magistrate or a judge will turn around and say, look, this is my opinion, I have the powers, I will do it. So we have to be a little bit wary of the misuse of that power. So having said that, I mean, I can only sum up the whole thing is that, yes, if we are venturing into other countries, there are issues that need to be handled. You have to think about what will happen back home also before you get something from there. And be very careful in how you go about doing things. That's all I can say, sir. And I thank you all once again. Beautiful presentation and articulation, sir.
I'd just like to add one more point, Shyam.
Yep.
On the perspective of globalization and what Rao sir was saying, see, the difficulty is, as Nalini ma'am says, we are Hindus by religion. So whether we become Canadians, Germans, Americans, or Indonesians, we will remain Hindus. That Hindus backpack we carry because it has extraterritorial jurisdiction. Now the conflict comes that when we live in a country, a county or a state in America or some part of any other European country, they say because you live in our territory, you are domiciled here, therefore our law will apply to you. So I turn around and say I am a Hindu. They say you can take this Hinduism back to your country. We are granting the divorce, and the divorce is for the asking. Ramakrishnan sir, it is for the asking. They may at best give you a decree nisi saying till you settle children and property, we will not make it absolute. In England, at least they do it. So the problem is, as Sir Ramana sir also said, for them it is a contract. For us, it is a ritual. For us, it is a religious issue. For them, it is a domicile issue. So it is a clash of jurisdictions. This is what Satya versus Teja Singh recorded. That does domicile confer jurisdiction on foreign courts? Can we claim to be Hindus? Now, the Supreme Court judgment in one of the cases has recently said that there is concurrent jurisdiction. So this has started creating a lot of doubts. And this judgment in Dinesh Singh Thakur versus...
I think that is in this case where Committee of Rights, sir.
No, sir, it is an anti-injunction suit. AIR 2018 Supreme Court 2094. AIR 2018 Supreme Court 2094. This is a judgment absolutely on a different note. It says that there is concurrent jurisdiction and an anti-suit injunction was declined. So they say if you are living abroad and you are domiciled abroad, Hindu business is also there. You Indian courts also have. They also have. So this is a thought process of globalization. Domicile versus personal law. Which law prevails? In India, personal law. In foreign country, domicile. So this is what originally what private international law said, comity of courts, jurisdiction of closest contact. So this is a complex situation, and the only way we can so to say change it is we have got the English Matrimonial Causes Act of 1857. the world has gone ahead. We need to bring in a limited breakdown for resolving certain marriages, not all marriages, as an exception, and as the unanimity is, hedge with safeguards, protect children, secure property rights, divide alimony, because a lot of assets of people are situated in India. So unless the children and the women, particularly if not earning, are secured, then irretrievable breakdown should not be given. But it is a discretion with the court. So this discretion, obviously, as law would evolve, somebody should read the Law Commission report of 2017, report of 2009, and work on irretrievable breakdown. And maybe Sham should go to Parliament and have a
So even that bill, it appears that it will select to the sent to the select committee. Thereafter, it does not come back. It appears.
like all bills on children and on marriages, that bill has gone in the archives.
Justice Ramakrishnan, there was a opposition to this from the the feminist groups which were there, because they said if you're going to make irretrievable breakdown of marriage as a ground for divorce, as suggested by the Law Commission, then you also simultaneously make a law which gives the women equal rights in the marital assets of the husband. Today, as the maintenance laws are there, it deals only with maintenance or alimony, depending on what. As a wife, I do not have a right in the marital assets of the husband unless my name is included in that. So the feminist group is saying that, okay, we don't want the husbands in a dead marriage, just going because on irretrievable ground. But
no, I don't. No, I think there is some provision I had made in the Succession Act or something. Some amendment has come out. I don't remember.
No, but don't have a concept of, as they call it, equitable and proportional distribution of the marital assets, which you have on the West Coast.
Even the service rendered by the wife can be taken into consideration for the purpose of acquisition of the property. I think that some concept has come in that way, it appears. I do not know.
Even in cases where the wife may not have contributed to it.
No, contribution in the sense, not money. The services that he has been contributed, taken to be as the contribution in terms of money, that will be valued in the terms of money, and that proportionate share will be provided in the property, even if it is in the name of the husband, when the divorce comes. And it appears that there is some discussion. I do not know whether it has become a law or not. There was some discussion on that.
Because today the Hindu Marriage Act does not have a provision for that. It just has a provision for interim maintenance and permanent maintenance, alimony, etc. Section 27 talks about the joint assets. We as lawyers try to tweak that around and say about it, but the courts are saying that is only limited to the stridhan of the lady under section 27. So there is, in my understanding, but of course I'm subject to correction.
Sridhan stands under a different footing because it is always the property of the...
No, but sir, what Nalini ma'am is saying, there is no provision in our laws for equitable distribution of marital as it is abroad. You see, in abroad, everything is 50-50, regardless of who owns it and how it came.
Including liabilities that are low.
Pluses and minus. So therefore, what
liability will not come.
No.
Liability will not come. It is always on the person who creates the liability.
What Nalini ma'am is saying, we have to balance breakdown with asset distribution, which is right.
Yes.
They both have to go together. So,
but in gender equality, liability should also come.
I think there is some discussion going on even in that aspect. It appears. I do not know whether it become a law or not. Yes. Because when the property, when you are going to divide, even the property was acquired in the name of the husband during the subsistence of marriage, then that will have to be given as some status, and the right will not be given to the wife. I think there is some studies going on that, and I do not know whether it has become a law or not.
Sir, the problem is we have a need-based maintenance law.
It's need-based.
1/3, 1/4, whatever is a barometer. Neha versus Sanjeev Kumar, Justice Anil Malhotra has tried to sort it out, but it is a very gray area. So there has to be a composite balancing of breakdown and asset thinking, and I think Nalini ma'am should be heading the committee for drafting such a law.
I will go to Parliament. She will head the committee.
She should first become an and select committee for all this. But she can be appointed in a specialist role contributing to family law. There will be find Nalini ma'am equals in Lok Sabha or Rajya Sabha.
Madam can look into Finland law.
Finnish law.
Finland is having equal share. Finnish, that is the only country where the services are converted into money. I was told by one of my friends who is employed in Finland.
Right.
So,
Yes.
So, sir, a wonderful evening as always with you, sir. Let us all thank Anil Malhotra, sir, for the wonderful presentation and the thought-provoking discussion that followed. And Mrinalini ma'am, thank you for that introduction and thank you for being part of the platform. And thank you very much, Justice Ramashan, sir, Justice Ramana, sir, KVJ Rao, sir, Raghuraman, sir, and all of you wonderful participants for your wonderful participation and inputs. And like the topic says, think before you get married. Once you get married, if you want to get a divorce, think again. And end of the day, let us have the experts say whether the divorce has to be got from heaven or hell. Let's say.
So the bottom line is, marry at leisure, marry in haste, repent at leisure.
Very good, sir. So till we meet again next week, please do take care and stay safe. Thank you very much.